worry, therefore, Aman Lekhi, that human rights activists and lawyers have is that this is going to give wide sweeping powers to the police without enough safety checks in place. Do you agree with that, or do you believe it was necessary to reform some of these colonial laws?
Well, Rajiv, there's many things which cause concern. There are some things which are good, but
what's good? What's good according to you? Because we've heard a lot of the bad things from Colin. Tell us first what's good.
No. You see, as far as the good is concerned, insofar as certain other offences, particularly enhancement of the punishment and dealing with those private offences is concerned, there are certain changes which are positive. However, when we are dealing with these laws, particularly in the context of a polity which is in some way going to be affected by the state, the expansive and wide-ranging cause which entitles the state to interfere cannot be unreasonably enlarged. And that is where the problems are actually stepping. There are 2-3 points I want to make over here. One, this is a case not of codification but recodification. Now this is very, very pertinent, because when you deal with recodification, you talk about how laws are developed and how aspects of law have become redundant or archaic. So that requires a scrutiny of the development of the law and development of the law to identify areas of concern. And areas of concern requires the collective participation and a reasoned deliberation, which is absent over here, apparent in the haste in which this whole thing has happened, and eventually it has been passed. So the basis of codification itself collapses. This is number one. Number two, insofar as the address is concerned, the address of the Home Minister is high on rhetoric and appeals actually to emotion. And I'll deal with one very significant aspect of it, where the Home Minister has made a distinction, in my opinion, a completely misconceived one, between Rashtradroh and Rajdroh, to say that, see, we've done away with Rashtradroh and we have only Rajdroh. Now, this is a completely misleading statement. Why? Because in law, there's a distinction between treason and sedition. As far as Deshdroh is concerned, that is treason. That is war against the state. Treason remains on the statute book. It was there under the old code. It remains under the new code. So as far as doing away with treason is concerned, that is wrong.
No, so they've not done away with sedition. They've not done away with sedition, actually widened its ambit.
No. They have not. First of all, they've retained, the basic distinction is wrong because treason is there. Number two, the description which is made of sedition is also wrong, because what is being suggested is that the old act permitted prosecution for acts protesting against governmental activity, which is again wrong, because as far as the old statute is concerned, there were two explanations, apart from a third which we are not concerned, which specifically excluded disapprobation of the government. It was not as if the law as it stood permitted the imposition of an offence of sedition mainly because you disagreed with the government. The problem with that law was not the content. The content which is there now is more or less similar to what was there earlier. The problem with that law was the ease of applicability, because the Supreme Court judgment had said that mere tendency, not intention, mere tendency could cause prosecution for sedition. So as far as the content was concerned, the content was defined. It was never allowed to transgress certain defined limits, and it did not cover criticism of the government. So this particular suggestion, to which there was much applause in Parliament at this distinction is concerned, is completely wrong. And it would have been more appropriate the person better versed in law dealt with this very technical aspect. Number three, even your program is talking about these are not colonial laws. Now, I have a very, very serious objection to this, because this suggests some kind of cultural hegemony of the past and internalization of some kind of subordination. What it ignores is that our laws are now distinctively Indian, and we have a very rich jurisprudence. And this jurisprudence is typically Indian, and there is nothing colonial about it. And the biggest tribute to that jurisprudence is that the altered laws draw upon the same law. It is not as if the content of the law has altered to say something different from what was understood earlier. The terminology has changed and the numbers have changed. So it is not a violent departure from the past.